Hello and welcome to Case in Point. Great to be with you. I'm Joanne Joseph.
It is never just and equitable to take someone's land and give them nothing.
Expropriation without compensation. Can the state defend its argument that public interest sometimes justifies nil compensation for land?
They came to arrest me. There were more than 15 or 20 cars all over the street. There were tactical teams and we were thrown in prison.
Is South Africa witnessing the return of so-called Hollywood-style arrests? And does public interest trump the rights of suspects? Well, AfriForum and the Institute of Race Relations have spent the week in court arguing against parts of the Expropriation Act. The Democratic Alliance and Vaderland-stigting have brought a separate case opposing the law. It provides for land reform, opening the way for expropriation without compensation. The President, the Public Works Minister, the Parliamentary Speaker, the National Council of Provinces Chair, the Economic Freedom Fighters and the Land Reform Minister are respondents in the case. Let's just remind you of some of the arguments made in court this week.
The DA's case consists of two primary challenges. Its mandates and its Section 19. There's no question that as is suggested, that the Section 19 challenge is a tag-along challenge. It's not. It's a self-standing challenge, and it's an important one.
This is not a protection for a class. It's for every person whose property may be taken by the state.
There are lots of difficulties that will arise here from, but you don't have to go there, because all you have to do is to find that legislation is contrary to Section 25(2)(b) of the Constitution, inconsistent therewith.
Well, joining us to discuss this are Worksman's attorneys, Director and Head of Land Reform, Restitution and Tenure Practice, Bulelwa Mabasa, Sia Sitole from the Association for Rural Advancement, and Founding Director of IRR Legal, Gabriel Kraus, who joins us online. Ms. Mabasa, welcome. And let me start it off with you. What does the law currently say about land expropriation without compensation?
So currently, the Constitution governs the issue of expropriation. It does so in Section 25. And the Constitution makes provision for just and equitable compensation. It then gives us guidance in terms of what factors to take into account when you calculate the expropriation. The argument goes that when you apply those factors in different cases, so in other words, by case basis, there may be circumstances that may notionally lead to zero compensation if you implement those sections. So, for example, if the property or land was a donation from a Crown grant, you don't give a value for that. If, for example, under market value, you have a property whose value is less than, or the indebtedness of that property through rates and taxes has minus market value, or if you have there's been no state direct investment and there have been no improvements on that land notionally, that could lead to nil compensation. So the position really is that in terms of the Constitution, it may be possible, it's taking into account certain factors that may lead to that. However, the general principle is that expropriation must be subject to compensation, which it must be just and equitable, which may be lower or even higher than market value, depending on the circumstances that are being looked at based on the 25(3) formulation.
So that is a very interesting nuance that doesn't often come through. So, Ms. Mabasa, AfriForum is arguing that sections 12.3, 12.4, 19.8 of the Expropriation Act should be omitted and section 19.2 amended because they're unconstitutional. Please just explain to us what specific issues they appear to take with those sections.
I think generally the argument goes that expropriation without compensation generally is unconstitutional. I think that's the major contention. The other contention is that the wording in section 12.3 may be widened in scope if, for example, those circumstances are not finite. So the argument goes that interpreted based on the wording, that scope may be widened to include other circumstances, and they say that is not what the purpose of the legislation is. And then in terms of Section 19, it's the question around the timing of when the expropriation takes place and when the payment, kind of happens. So currently, the wording is such that if an expropriation happens, that expropriation can take place while the parties are negotiating, while the parties are arguing around price and so forth. The counter argument to that is that that is not new in our law, because similar to tax laws, you have laws that say, you pay now, you argue later.
Yes.
So it's very difficult to point at a distinct issue that goes into unconstitutionality, in my view, because I think those circumstances that are being complained about in Section 12 give guidance to the state around what could lead to expropriation without compensation. But the Act on its own and read holistically is almost kind of word and verse from the Constitution. So I don't see that the entire Act could be seen to be flawed as unconstitutional in its totality. At best, there could be the sections that are being complained about could be remedied, right, either by reading in or the kind of the underlying constitutional principles that courts use all the time. So I think to move away from the point is an important part about the separation of powers, and that is that the courts must be slow, and they must be slow to put themselves in the position of the legislature. They must defer. It's a principle of deference. They must defer to what the legislation intended. And of course, lastly, which you didn't ask, was the issue around provincial mandates, which is more of a procedural issue that was raised by the DA.
I do want to bring that in. Okay. I definitely will go there, but thank you for explaining that in such detail for us. Mr. Kraus, let me bring you in here. You've heard what Ms. Mabasa has to say. You feel similarly to AfriForum about expropriation without compensation, but she's making the point here that you're going to battle to argue the issue of unconstitutionality, because all it might take really is an amendment or a rewording or a reading in that really is a minor thing. It doesn't throw the baby out with the bathwater. What do you think about that?
I don't know. I do disagree. We have a slightly different view to AfriForum, but we've already had our advocates make their main arguments to the court. And I think they made an important impression. To be clear, there's one group that says never null. So this Act says null may happen, not it automatically will happen, but it can happen. And there's opponents who say null can never happen. What we have said for years now is that we agree that null may happen in some circumstances. Where we disagree with the Act, where we find the constitutionality of the Act, the test of constitutionality clearly fails, is on a couple of scores. One of the scores is the specific provisions, the specific facts, where the Act says if these facts arise, then it may be null. Let me take you to those facts. In 12.3d of the Act, it says an owner may receive null compensation if their land has been subsidized or invested in by the government, by the state, to a value that equals or exceeds the value of the land. So we said in our founding affidavit, we can see hundreds of thousands of land reform beneficiaries where the state has invested or subsidized into that land, either invested into the acquisition or subsidized the subsequent use of it. Now, if you want to expropriate that land from a land reform beneficiary for whatever purpose, either another land reform purpose, you think these guys aren't doing so well, you want to put someone else there, or for another purpose, what's going to happen? Are you going to give them null compensation for their land repeating the injustice basically of the past? Or are you going to undercompensate them? Are you going to pull the amount down that was subsidized from the market value or from the value in their hands? And that is effectively what the Act requires. It doesn't say that necessarily it must be nil, but it does say it may be nil. And the Speaker, the President, the EFF, everyone who wrote legal papers in response to this said, yeah, it may be nil for land reform beneficiaries.
So your case, sorry to come in there, Mr. Kraus, but your issue is basically, it's limited to the experience of land reform beneficiaries and no other South Africans. Is that what you're saying to me?
That's just 12.3D. Then we can go to 12.3A, which the first speaker addressed, the speculative landholders. So if someone owns land, they're not living on it, they're not using it, but they've bought it for $1 million, they want to sell it for $2 million. It says they may get nil. Now, of course, there are some people who have an opinion about absentee land owners and think these are devilish folk and they should be punished. But the Constitutional Court has said in a case, FNB, a unanimous judgment, I will quote from that case, it says, a speculator has no less a right of ownership in goods purchased exclusively for resale, merely because she has no subjective interest in them, but sees them only as objects that will produce money on resale. In other words, the Constitutional Court has already decided whether your rights, your interests should be less because you are a speculator than someone who is using their property in another fashion. The Act is saying your interest is less. You can have that amount pulled away from you because you are not using it the way Parliament wants you to use it. But the court has already interpreted Section 25 of the Constitution and said your interest is not less, your right is not less. And I can keep going. There are 4 subsections.
Sorry, Mr. Kraus, I'm going to have to just interrupt you there because we haven't heard from Mr. Sithole yet, and I do want to bring him into the conversation. Mr. Sithole, you're acting as a friend of the court in this matter, and you're suggesting that steps have to be taken towards an equitable type of redress. But is land expropriation the way to do it?
Thank you so much, and greetings to my fellow panelists. I think the starting point here is the question that you have put to us. Can nil compensation pass the constitutional test or constitutional muster? Of course it can, because the Constitution as it stands has Section 25, that has Section 25.3 that talks about the 5 key elements that have to be looked at concurrently. Now, our speakers here, Ms. Mabasa has outlined it perfectly, and our second speaker has really missed the point here. If we agree that the 1975 Expropriation Act, which is pre the democratic era, talked about public purpose, and we know that the 1996 Constitution, which is our guiding law in this country, the Apex law, talks about the nation's commitment to land reform being of public interest. So we've added to public purpose, we've added public interest. So we can't now go back and forget how land was lost in this country and how people were forcibly removed and how people were dispossessed of land. This act simply tries to give effect to a constitutional mechanism that is already there. And this act simply tries and brings in a special case, which will obviously be on a case-by-case basis, where land can be expropriated with nil compensation. Land can be expropriated in the current constitution, we know that. The only, what this act tries to do is give steps in how you do that in terms of arriving at a nil compensation. Now, we are the first to concede that there is no way you can expropriate with nil compensation in a blanket format. It has to be on a case-by-case basis. And if you look at those 5 principles of market value, current use, purpose of expropriation, historical use, state investment, and so on. If you look at those factors concurrently, it is clear that there are definitely cases where compensation can be lower than market value, right up to the point of nil compensation. And the easiest example is labor tenants and farm dwellers, people who have occupied land and live on the land and have lodged claims to own that land. And there are laws of general application, like the Land Reform Act, Labor Tenants Act of 1996, that gave those citizens the right to claim the land that they are on, that they have used over generations. Now tell me, how has a landowner, a commercial farmer, gained any economic value over time on land that has been occupied by labor tenants and farm dwellers, how can they now come and claim that if that land is to be expropriated and transferred in terms of ownership to those families, how then do you explain that it must be the current owner who must be compensated when they have derived no economic benefits over time? That is just one example. The second speaker talked about land that is being held for speculative purposes. So those are examples that show you that there are many cases where you can expropriate without compensation.
All right, I'm going to leave it there for now and stay with us, because after the break, we discuss the DA's argument that the Land Expropriation Act passed is irrational. More in just a moment. What does compensation in regard to land reform actually mean? Well, that was what was discussed in the Western Cape High Court this week. Take a look at some of the arguments made.
To identify set instances where the provisions of nil compensation may be just and equitable for expropriation in the public interest, to repeal the Expropriation Act of 1975, and to provide for matters connected therewith. So part of the Act is to identify instances where it may be just and equitable to offer nil compensation.
And compensation, by its nature, entails that you are rectifying a wrong, and so it is never possible to compensate someone with nothing. Judge Saldana, you made a point yesterday, which is that there's an additional modifier to compensation, which is just and equitable. Now, obviously, if compensation always entails the rectifying of a wrong, and that can never entail zero, by the nature of what compensation means, and zero can never be amount, and one can never pay zero, it is also the case that it is never just and equitable to take someone's land and give them nothing. Giving someone nothing in those circumstances amounts to confiscation and not compensation.
Well, of course, we're putting all these arguments under the microscope. Ms. Mabasa, the DA arguing there that the way this law came into being was irrational. It's focusing on a situation where the expropriating authority and landowner can't reach an agreement, and then a court has to deliver a notice of expropriation. I mean, is there an argument to be made for the manner in which they're arguing this?
So as I said in the beginning, I don't think the Act is irrational as it is. I formed part of the Presidential Advisory Panel on for land reform, and it was interesting because the recommendations that we made then in 2019 to the President was around the fact that the 1975 Expropriation Act that was in application was unconstitutional, because that 1975 Act was an act that made provision for market value compensation, contrary to the Constitution. So in fact, the Expropriation Act of 2024 is a necessity, and it comes, over 40 years too late. So in fact, there is a constitutional injunction in Section 25 that says that we must have an Expropriation Act that aligns itself with Section 25(3). So the argument that the Act section that the Expropriation Act of 2024 is per se irrational is incorrect in my view, because it's linked directly to the injunction in the Constitution that says the nation's commitment to land reform is as important as the protection of the right not to be deprived of property. So Section 25 is a balancing act. It recognizes that whilst property owners have a right not to be deprived of property, it also realizes that the state has expropriation powers that it can and must use when it comes to, for example, the nation's commitment to land reform.
I want to ask you about these provinces. The DA is saying provincial delegates weren't lawfully authorized to vote on behalf of their provinces in favor of the Act. I mean, do you think that's going to stand in court?
So it's going to be interesting how the court treats that argument. We know that constitutionally, there's a constitutional principle that says procedural fairness is important. We know that there are certain pieces of legislation that have been declared unlawful because of procedural issues. The example of that I can bring is the Lamusa judgment, when President Zuma tried to reopen the land claims in 2014. But I think what distinguishes this case is that the expropriation bill went through a myriad of iterations. It's gone through an extensive consultation period, public consultation process. So it's unlikely, in my view, that the court will uphold the principle around the provincial mandates if substantially the substance of the act is linked to what the Constitution envisages. But if the court is minded to accept that argument, the outcome of that would be that the entire act could then be struck as invalid. But then it also opens a question, does this court have the authority to do that, or is that within the realm of the Constitutional Court to strike down legislation?
Very complex indeed. Mr. Sithole, do you take AfriForum's point that a landowner's property could be expropriated without compensation before a court has ruled on the validity of that and the amount? And so the landowner, already having lost their land and source of income, would have to fight in court for an inordinate amount of time and of course would have to do that at their own cost while government uses taxpayers' money to fund their battle.
No, and that is a fair point. But I think we need to look at it. I think Ms. Mabasa has outlined it perfectly, that Section 25 seeks to strike a balance. There is an understanding. The property clause respects and protects the rights of landowners as much as it does in trying to ensure that those that through historical injustices lost the rights. It's a balancing act. And we need to really understand what the term public interest means. If the drafters of our Constitution, in their wisdom, said that the nation's commitment to land reform includes public interest, I don't know who can argue that land reform is not of public interest. I think we all agree, whether it's AfriForum or whoever else, we all agree that land reform is of public interest. What is in front of us is how to go about it. And for me, what you are saying, we need to separate expropriation and compensation. Those are two things. The argument that if there is an argument for an expropriation, we must allow that. Expropriation is not a new thing, colleagues. We have seen expropriation being advanced by Public Works or Department of Transport for public purpose. And compensation is then argued afterwards. There's no argument that if you're going to build a national route and your house is in that route, the state will expropriate your property. And then you will go to court to agree on the amount. But you can't argue on the expropriation because it's of public purpose. So now if we all agree that land reform is of public interest, then the case is the same, that we must separate the two. Where we agree that for public interest, there must be an expropriation, then allow the courts to do their job in arriving at a just and equitable amount of compensation. And our colleagues, many colleagues, fail to really talk about what just and equitable means. Just and equitable means, in English, means exactly that. What is just, what is fair, considering all factors. And what is equitable, considering all factors and historical factors as well.
I want to get Mr. Krause to respond to that, because this issue of the public interest, I mean, how does one begin to weigh that up when you're talking about land being expropriated for a public road to be built or a hospital or a school, and in very particular cases we've had this example of landowners only agreeing to give up their properties at exorbitant prices that are not nearly market related. How do we balance that, Mr. Krause, the public interest with what looks to be, on the face of it, the greed of one owner?
I don't know about the greed of one owner, Joanne. Under the law, if you are expropriated, you don't get to decide the price. A court, you either agree with the thing. If you're asking for too much, then it goes to court. Really, the public interest point is brought up by both of the speakers to create this picture that on the one hand, there's people who want strong property rights. People like me, I want strong property rights. And on the other hand, there's people who want good land reform. And, you know, that's not me, or by implication, that's not AfriForum or something. But in fact, this is how it works. Strong property rights and strong land reform go hand in hand. Why do I say that? This act undermines strong property rights and it undermines land reform. How does it undermine land reform? I've just said Section 12(3)(d) says that every single land reform beneficiary if they are expropriated, can suffer undercompensation, pulling down the amount that once they were subsidized. There's no one else. You know, if you have a restitution case, 90% of people take the money, they take the cash. They have that money, they can do whatever they want with it. But this act says, if you took the land and then the government comes again to expropriate you, it doesn't have to pay you. It can just take that land away from you. That means they weren't given a title deed in the true sense, because the title deed in a true sense means if we take it away from you again, we must compensate you. It means that title deed is just like a apartheid era permission to occupy certificate.
I must just interrupt you there because I've got Ms. Mabasa, who's our land reform expert. I've got her nodding furiously against that in studio.
Well, I would like to just finish one point, if I may.
Yes, go ahead.
To say that on this, the Constitutional Court itself, you know, earlier I mentioned the precedent on speculation. Neither of the other speakers addressed that. Now I will quote directly what the Constitutional Court has said about this issue of whether property rights and the history are in conflict or whether they come together. The court said, I'm quoting directly from a unanimous judgment, the blatant disregard manifested by racist statutes for property rights in the past makes it all the more important that property rights be fully respected in the new dispensation, both by the state and by private persons. Right. So the court didn't say that you have the strong property rights of white people and you have those who are excluded. Now you fix it by bringing the strong property rights down. The court said, because of how bad things were, you must be extra careful to keep strong property rights and bring more people up into that, so that land reform beneficiaries are given true rights, the kinds of rights that are equivalent to the rights that those who were privileged used to have.
All right.
Those rights included protection from expropriation without compensation.
All right, I'm going to throw it back to you, Ms. Mabasa. Is there anything from a legal point of view that you disagree with there? I've literally got 20 seconds.
So it's important that land reform objectives, the land reform policy, is not what this act deals with. And our speakers bringing in things around restitution claimants is exactly the opposite of what the Expropriation Act deals with. Expropriation is simply the state's power to acquire property when it needs it for a public purpose and a public interest. There would be a case of unconstitutionality if the state were to look at a restitution claimant and seek to expropriate them, because they would be at odds with Section 25(3). A restitution claimant would be using that property. The current use would be that it would be used, the property, and the history of acquisition would also be applied. If you apply those 25(3) facts and you try to expropriate without compensation, that would be unconstitutional, and that is not the purpose of the Expropriation Act.
All right, I'm going to have to leave it there, and I'm sorry that I can't speak more to the three of you because it really is such a fascinating topic. But of course, we have run out of time. Thank you all for making yourselves available for this important conversation. When we come back, it's lights, camera, action as Hollywood-style arrests come back into fashion. We explore this after the break. This is Case in Point. They're characterized by speeding police cars bathed in flashing lights and screaming sirens, while suspects are often apprehended on private properties and handcuffed before the waiting media. Hollywood-style arrests have been slated in the past, but more recently they appear to have been revived. Are any laws being broken in the course of these arrests, and are the suspects being discriminated against? Our producer, Sebe Butelezi, caught up with one man who says his life has been irreparably altered by an arrest conducted in full view of the cameras.
Blue lights, armed tactical teams and media cameras ready to capture the unfolding arrests. Suspended Egoruleni Metro Deputy Chief Julius Mkhwanazi was arrested. On the same day, Witness K was also arrested.
Here is the suspect coming out now.
Though she concealed her identity, her home, just like Mkhwanazi's home, were on full display, making it easy for those who know them to identify them. These are some of the public arrests that South Africa has been witnessing in recent times. Observers question whether the country is returning to the so-called Hollywood-style arrests seen during the days of the now disbanded Scorpions. Critics say these arrests are intended to humiliate suspects through parading them in front of cameras.
9 government officials from the Departments of Home Affairs and Correctional Services have been arrested on charges related to corruption.
The officials were allegedly involved in illegal releasing.
On 18 March 2018, this former government employee watched his life unravel after police announced they had dismantled what they described as a corruption syndicate.
The case from the beginning had media attention until we were granted bail. On the day they came to arrest me, there were more than 15 or 20 cars all over the street. There were tactical teams and we were thrown in prison.
26 days later, he was granted bail. He says years later, the headlines have disappeared, but the consequences haven't.
It affected me because now I can't do anything. Even today, my fingerprints are still in the system, reflecting that I am awaiting trial. I recently applied for a PDP and it brought back results that I have to clear my fingerprints, and I was acquitted 2022. I've been trying to clear my name since then, but nothing is happening.
Worse still is the judgment that still follows him.
My neighbors still treat me like a criminal.
He believes the dramatic arrests are done as a way for those in authority to gain favor.
In our case, the investigating officer at the prison got a promotion and the one who dismissed us also got a promotion. So I also realized they were gunning for promotions at the expense of our lives.
Although the court ruled that he should return to work, he is afraid history will repeat itself.
If they could reinstate me, then they will plant something on me. They must pay me from 2018 until now.
Sebe Buthelezi, case in point.
Well, let's tackle this issue with our panel. Attorney Flens Koza and Executive Director of the Freedom of Expression Institute, Samkelo Mokine, are with us in studio. Good evening, gentlemen. Mr. Mokine, let me start with you. We've all seen these types of arrests take place on TV, especially in regard to high-profile matters. Has the manner in which they've been carried out ever created a sense of discomfort in you?
Yes, definitely, especially in cases where the arrests go on to private realm, like next to people's houses where everybody can, in the neighborhood, can actually identify whose house is it, or people in the know who know that part of town or the township. So that has elicited a lot of concern. But in cases where it happens in a public place, like at a courthouse, then it's a bit more difficult. It's a bit more open. It's a public place, and there we just have to grin and bear the balance between the person's privacy and the fact that it's something in the public interest.
That's a very interesting thing to drill down to, Mr. Koza. Some viewers, of course, do consider these types of arrests distasteful. But from a legal point of view, do they actually break the law in any way?
Thank you so much, Ms. Joanne. And most definitely they do break a law to some extent, because you will understand that the reason for any form of arrest is to secure the accused person to come before court. But that is it's an intrusion and it's a limitation of someone else's rights or a person's rights. And our constitution provides us with certain rights. One right that this matter speaks to is the right to dignity. The second right that it speaks to is the right to privacy, which rights are already limited by an arrest. So bringing along the media or bringing along others to come and then intrude further into these rights, it's actually a constitutional violation by itself.
I mean, it looks like there are options here. In many situations, suspects are not necessarily resisting police. They're not endangering the public. They are cooperating with the law. Why would police necessarily opt for this kind of arrest rather than to make use of the Criminal Procedure Act to either summon that person to a police station or send them the notice to appear in court?
Most definitely, I agree with you. Actually, that should be the process. So an arrest is used as a last resort in terms of the scheme of our legislation, rather of our act, because if you look at Section 40, it says that the least intrusive method must be used. That would include your summons, that would include your you inviting to the police station. But because we have now become this generation that is so media frenzy, who want to be very fast. I love the media, and the media has a very important duty to cover and to inform the nation. But that must not come at a cost of someone else's rights and someone else's dignity, someone else's privacy. That must be balanced, because an arrest by itself is a serious intrusion to someone's privacy. So most definitely that should have been happening. But recently we have seen actually, and we've witnessed that in most cases you find out that those options are not even considered. If you look at it, it's as if they arrest even to investigate, of which is something that must be frowned upon.
I want to bring into the conversation at this point Ulrich Roux, criminal lawyer, and one of our guests, Mr. Roux, said a moment ago that arresting people in their private spaces is one thing, in this kind of Hollywood-style arrest type maneuver. But if one is doing it in public places like courthouses or other public spaces, he believes it is permissible. Would you agree with that?
Well, I must say that I agree with all of the views that your other guest has shared now. The fact of the matter is that the purpose of an arrest is to bring a person before court. And as just pointed out now, it must be the last resort. Police should attempt to bring people before court with a J175 summons or asking them to hand themselves over at the police station to process them and then to take them through to court. So we have most definitely seen these Hollywood-style arrests taking place. The difficulty with that is that even though it is an infringement of a person's constitutional right to an extent, the law does not say that it is unlawful for the police to do that. So, as a practicing attorney in this field, we communicate with the police, we interact with them, and we come to agreements to bring people to police stations in order for them to be processed and then to be brought to court. But there's unfortunately nothing preventing the police from arresting a person and going out and applying for a warrant of arrest to bring them before court, because it is one of the means to bring a person before court. Now, certainly it is unnecessary, in my view, to involve the media, to have these arrests plastered all over our television screens and all over our newspapers. But unfortunately, there has never been a case against the police where they've been found to have acted unlawful when they've done this. We have seen matters where people institute civil claims against the police and the prosecution for unlawful arrest and malicious prosecution, but a civil claim like that only arises once a person has been acquitted of any charges that they would have been facing. So it is something that we are seeing a lot more of these days, but unfortunately for the public out there, I don't think that it's going to start diminishing. I in fact think that it would most likely increase, because there's nothing preventing the police from doing this. As I've said before, should you start questioning a policeman as to why the media were there, there's so many fingers that can be pointed, and they can just shrug their shoulders to say, well, the media, it is also their duty to keep the public informed, and they have that right. So, as correctly pointed out by our other guest, I do not think that right trumps a person's constitutional right to freedom and to freedom of movement, which is obviously hindered upon when an arrest does take place. But I do not see this going away very soon, to be honest with you.
This is a very interesting point that Mr. Roux is mentioning here, Mr. Mokine. This is also the question of what is in the public interest. And the media certainly is deeply driven by that commitment to the public interest, right? Post the long arc of the Zondo Commission, for argument's sake, we didn't see the arrests that we had hoped to. This left South Africans deeply disappointed. It left them angry with the justice system. Now, I wonder, in the current climate, is it what citizens need to see? Do they need to witness these arrests in the manner in which they're happening to restore faith, public faith in policing first of all, but also to remind people the rule of law is still very much in place?
Yeah, I mean, the adage that justice must not only be done, but be seen to be done.
Exactly.
Is part of what would inform possibly the police and the justice system. So a lot of people didn't see any arrests, and people have been asking consistently, when are we going to see people in orange overalls? But the minute you start actually seeing the visuals of people being arrested, being processed, being brought to court, that makes people and the public feels that, you know, there is information flow. We can see justice at work, and the public is much more restful for it.
I mean, I also have a question for you about high-profile individuals, and we know that, I mean, they should not, in theory, be treated differently to any other citizens. But many high-profile people make a living off their reputations, right? Yeah. They could be irreparably damaged by a theatrical arrest, especially if the person is found to be innocent in the long run. Should any additional thought be given to that, Mr. Mokine?
I mean, if definitely, but if people, as Mr. Roo has pointed out, that the person is able to or knows in advance of an arrest, people are sometimes given the option to go to a police station and hand themselves over. And sometimes attorneys are able to negotiate when they can bring their clients in. So there are those options to explore, plus but that only happens if you know in advance that you're going to be arrested. But that definitely must be given a thought.
All right, we're going to take a short break now and continue to explore this question around Hollywood-style arrests not being against the law on paper, but when we come back, we'll delve deeper into whether these types of arrests impinge on the other rights of suspects. Stay with us. Welcome back. The South African National Editors Forum says most cases where the media's covered arrests involve high-profile individuals. SANEF's Hopewell Khadebe says these arrests are meant to demonstrate accountability.
There is enough precedence in our courts to show that public figures who are in that position of trust, when they are being arrested, it's supposed to be seen. Number one, and it also shows that police are doing their job, that there is accountability in South Africa of public servants who are supposed to be appearing in court for wrongdoing, and it regards fraud, it regards them maybe a variety of crimes, of course, variety of even money laundering, like it happened with our former Speaker, Nosiviwe Mapisa Nqakula. Often, we don't get the cameras following ordinary people. It is celebrities that get to face that wrath of the media by getting to be known on the day in which they get arrested. But they've already gotten an advantage anyway, because often by the time they go before the court, their cases are thoroughly investigated by then. Even the prosecution is nearing the preparation to go on trial.
Well, back to our panel at this point. And Mr. Khoza, typically we don't name a suspect as the media until they've appeared in court and pleaded. But if we're on location filming this, I mean, clearly a fine line is being drawn. We may not mention the suspect's name, but our viewers will see who the individual is. What does that mean from a legal point of view? What are the implications?
The implications, therefore, is that it defeats the purpose. So if we are going not to be mentioning the name of the suspects, yet the public can still see the face of the suspect, it defeats the purpose. And I just noticed the recently flighted images of Lieutenant Mkhwanazi. And it's one case in point whereby an arrest, even in that case, my considered view was that was not necessary at all. Because even if you look at the cases that he's facing are cases that happened previously before his even current arrest. So there, summons would have sufficed. But then you would be having this gentleman being arrested in front of the media, and the media already knew that it's actually going, it's him who's getting, the public already knew that it's him getting arrested, and they already saw him. So it basically defeats the purpose. And then when they come before court, already it's public. To some extent, in some cases, there's what we call identification parades. It even defeats the purpose of those identification parades, because it already appeared. We don't know whether that has already happened or not, but now we are already in the public domain. So everyone has seen you. It even undermines investigations themselves.
Very interesting indeed. I mean, Mr. Mokine, what typically happens in a case like this is that law enforcement officials will call up the media. They'll say, we're going to arrest someone at this address, at this time, please arrive and film it. And essentially, I mean, whether you want to call that a public relations exercise on the part of police, certainly the media feel the responsibility to bring the public that breaking news story, to keep a hungry news-watching public, addicted to the stories that we continue to run? Is it up to media houses to say, we're not going to take the scoop, we'll just sit back and just let this unfold, and eventually when the person gets to court, we'll make sure we're there?
Yeah.
Bit of an unrealistic expectation, wouldn't you think?
Yeah, there is a right to be informed, and the media is ensuring that there is information flow. But as well, the media does do its own investigations and making sure that when these people come and appear. So when it comes to Lieutenant Mkhwanazi, I think it's been in the public domain that a fourth arrest is imminent, and I think the media were on standby, irrespective of whether somebody might have called them, but they have been expecting it, and they would have made sure that they get that scoop.
Mr. Roo, let me bring you in here, and perhaps we'll wrap it up here, because if we return to our producer's insert that tells the story of someone whose life has been drastically altered by this kind of Hollywood-style arrest, and he hasn't been able to move on with his life, but the charges have not gone anywhere. You spoke about the issue of a civil prosecution, but earlier Mr. Khoza also spoke about the issue of an attack on the right to dignity, which to my understanding is a constitutional issue. Has anything ever been fought on that level to try and receive recompense for a Hollywood-style arrest?
No, most definitely it has. The difficulty, and just to add on to your earlier question as well, when a person is arrested, remember that they are still seen as innocent until proven guilty. That old cliche still rings true very much. And the problem with these high-profile Hollywood-style arrests is that the minute that a person is arrested and it's all over the media, their reputation and their dignity has most definitely been impaired, and even more so should they be acquitted at the end of the day. So we have seen cases in the past where people have instituted civil action for damages against the police and the NPA. They must obviously prove that, take for instance, Mkhwanazi was arrested for the fourth time yesterday. But should he be acquitted of all four of these charges, and he can prove that the extensive media coverage on his arrests, as well as the police involvement in securing the media's presence during these arrests, had such an impact on his dignity and his reputation that it is impossible for him to ever work again. It's impossible for him to secure employment again in future. Then he will most definitely have a damages claim against the NPA and the police. Unfortunately,
not the media, Mr. Roo.
Sorry?
But not the media. That is what is of interest to me as well. Has the media ever been or has there been attempted prosecution against the media in a case like this?
Well, it's only if the media can be proven to have reported falsely on matters and to have distorted the real facts and to have misrepresented to the public what the true facts are. Then most definitely, we do get defamation cases against the media. The amounts awarded, though, in those successful matters hardly ever reach the actual damages that has been suffered by these people, should they find themselves in a position where the media has distorted the facts, or whether they have falsely portrayed a certain version to the public. It is a big problem, because the minute that an arrest is carried out and the media is present and it's all over our television screens and our newspapers, that person's dignity and his reputation, his or hers, has most definitely taken a very serious knock, and it will most definitely be very difficult to recover from that.
Very interesting indeed. Thank you all for your insight into this really fascinating story, and I think it's something that's not going to stop anytime soon. So hopefully we'll be able to reflect with all three of you in the future at some point. Thank you for joining us, gentlemen. Well, every week we bring you a new fact about the law. While the courts are still debating land expropriation without compensation, did you know that currently residential and other land used for shelter are protected by the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act 19 of 1998. The Act secures the owner's rights to evict individuals who occupy residential land or buildings without express permission, institute legal proceedings in either the magistrates or the High Court for a lawful eviction order, a legally guaranteed and fair judicial evaluation where the court balances the owner's constitutional property rights against the personal circumstances of the unlawful occupiers, have the sheriff of the court and police, if authorized, to execute the removal of unlawful occupiers through an eviction order, claim outstanding arrear rentals, holding over damages or compensation for the unlawful occupation. But it is illegal for owners to cut off water or electricity, change door locks, intimidate or remove the personal property of unlawful occupants without a formal court order. Well, before we wrap up our show tonight, if you're facing a legal or justice issue that you'd like us to explore, please email us on caseinpoint@sabc.co.za. And that is a wrap from us for tonight. We'll see you next Thursday at 8 p.m. Take care from the Case in Point team. Bye-bye.